Thank you, Mr. Chief Justice, members of the Senate, Leader McConnell, Democratic Leader Schumer. It's also my privilege to represent the President of the United States before this chamber. Senator Schumer said earlier today that the eyes of the founders are on these proceedings. Indeed, that's true. But it is the heart of the Constitution that governs these proceedings. And what we just heard from Manager Schiff, courts have no role, privileges don't apply, what happened in the past, we should just ignore. In fact, Manager Schiff just said, try to summarize my colleague's defense of the president. He said it not in those words, of course, which is not the first time Mr. Schiff has put words into transcripts that did not exist. Mr. Schiff also talked about a trifecta. I'll give you a trifecta. During the proceedings that took place before the Judiciary Committee, the President was denied the right to cross-examine witnesses. The President was denied the right to access evidence. And the President was denied the right to have counsel present at hearings. That's a trifecta. A trifecta that violates the Constitution of the United States.
The defense argument emphasizes the violation of fair trial rights and calls the impeachment process unconstitutional. This point raises questions. Can impeachment be considered legitimate without respect for principles of fairness? Do you think fairness should come before political priorities?
Mr. Schiff did say the courts really don't have a role in this. Executive privilege, why would that matter? It matters because it's based in the Constitution of the United States. One manager said that it is you that are on trial, the Senate. He also said that, and others did, that you're not capable of abiding by your oath. And then we had the invocation of the ghost of the Mueller report. I know something about that report. It came up empty on the issue of collusion with Russia. There was no obstruction. In fact, the Mueller report, to the contrary of what these managers say today, came to the exact opposite conclusions of what they say. Let me quote from the House impeachment report at page 16. Although President Trump has in times invoked the notion of due process, an impeachment trial, an impeachment inquiry is not a criminal trial and should not be confused with it. Believe me, what has taken place in these proceedings is not to be confused with due process. Because due process demands, and the Constitution requires, that fundamental fairness and due process, we're hearing a lot about due process is designed to protect the person accused. When the Russia investigation failed, it devolved into the Ukraine. A quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason. But instead we get two articles of impeachment. Two articles of impeachment that have a vague allegation about a non-crime allegation of abuse of power and obstruction of Congress. Managers, right here, before you today, who have said that executive privilege and constitutional privileges have no place in these proceedings. On June 28, 2012, Attorney General Eric Holder became the first United States Attorney General to be held in both civil and criminal contempt. Why? Because President Obama asserted executive privilege. With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, the White House assertion of privilege is backed by decades of precedent that has recognized the need for the President and his senior advisors to receive candid advice and information from their top aides. Indeed, that's correct. Not because Manager Schiff said it, but because the Constitution requires it. Mr. Manager Nadler said that the effort to hold Eric Holder, Attorney General Holder, in contempt for refusing to comply with various subpoenas was, quote, politically motivated, and Speaker Pelosi called the Holder matter, and I quote, a little more than a witch hunt.
The topic of executive privilege is addressed here, relying on the Constitution and past precedents. This principle serves as a defense to preserve the power and independence of each branch of government. Do you think the impeachment process should follow established constitutional standards to avoid political bias?
What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the president was sworn into office, there was a desire to see him removed? I remember in the Mueller report, there were discussions about, insurance policies. The insurance policy didn't work out so well. So then we moved to other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to the Supreme Court as well. It was then Justice Rehnquist, later to be Chief Justice Rehnquist, who wrote for the majority in United States versus Russell in 1973. These are the words. We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. That day is today. That day was a year ago. That day was in July when Special Counsel Mueller testified. I am not today going to take the time to review, and I will do it later, the pattern and practices of irregularities that have gone on in these investigations from the outset. But to say that the courts have no role, the rush to impeachment, to not wait for a decision from a court on an issue as important as executive privilege, as if executive privilege hasn't been utilized by presidents since our founding. This is not some new concept. We don't waive executive privilege, and there's a reason we keep executive privilege, and we assert it when necessary. And that is to protect the Constitution and the separation of powers. The president's opponents, in their rush to impeach, have refused to wait for complete judicial review. That was their choice. Speaker Pelosi clearly expressed her impatience and contempt for judicial proceedings when she said, "We cannot be at the mercy of the courts." Think about that for a moment. We cannot be at the mercy of the courts. So take Article 3 of the United States Constitution, remove it. We're acting as if the courts are an improper venue to determine constitutional issues of this magnitude. That is why we have courts. That is why we have a federal judiciary. It was interesting when Professor Turley testified before the House Judiciary Committee in front of Mr. Nadler's committee. He said, we have 3 branches of government, not 2. If you impeach a president, if you make a high crime and misdemeanor out of going to courts and abuse of power, it's your abuse of power. You know, it's more than that.
The first thing I want to say on the issue of witnesses is that the House manager just got up here and described the articles of impeachment and the charges. There is no plural here. That's wrong. There's one article of impeachment and there's one charge, and that's incitement of violence and insurrection. What you all need to know and the American people need to know is, as of late yesterday afternoon, there was a stipulation going around that there weren't going to be any witnesses. But after what happened here in this chamber yesterday, the House managers realized they did not investigate this case before bringing the impeachment. They did not give the proper consideration and work. They didn't put the work in that was necessary to impeach the former president. But if they want to have witnesses, I'm going to need at least over 100 depositions, not just one. The real issue is incitement. They put into their case over 100 witnesses, people who have been charged with crimes by the federal government. And each one of those, they said that Mr. Trump was a co-conspirator with. That's not true. But I have the right to defend that. The only thing that I ask, if you vote for witnesses, do not handcuff me by limiting the number of witnesses that I can have.
This point raises the question of the need to expand the witness list in order to achieve justice. What are the responsibilities of both sides in the investigation process, and what might be the consequences if the defense's ability to present additional evidence is restricted?
I need to do a thorough investigation that they did not do. I need to do the 911 style investigation that Nancy Pelosi called for. It should have been done already. It's a dereliction of the House manager's duty that they didn't. And now at the last minute, after a stipulation had apparently been worked out, they want to go back on that. I think that's inappropriate and improper. We should close this case out today. We have each prepared our closing arguments. I had 8 days to get ready for this thing. But we each had those 8 days equally together to prepare ourselves. And the House managers need to live with the case that they brought. But if they don't, please, in all fairness and in all due process, do not limit my ability to discover the truth. That would be another sham. And that's the president's position, my position.
The defense calls for the conclusion of the case, emphasizing the importance of a clear and impartial judicial process. This call prompts reflection on how to balance the completion of the political process with the need for full legal clarity.